Good day, Internet. This is Chavez and Valko, the key to your immigration solutions. I am Senior Associate Benjamin Hamilton, and with me, as always, is Associate Andrew Craven. Good to see you, Andrew.
Good to see you, Ben. How are you doing today?
I'm doing all right. And if you see our smiling faces, we're here to talk about all things employment based immigration. That is what we do all day, every day. Today, we're going to be talking about what happened in 2021 and then what we think is going to happen or that is on the books for 2022 in terms of changes and updates. So we're just going to jump right into it. Andrew, what was kind of the first thing that started us off in January of 2021?
Well, the U.S. Federal District Court struck down the new H-1B lottery rules.
So that rule was actually or put forth in January of 2021, and it was struck down, but the vacation was stayed for a little while, and then it was finally lifted in March. And then in December, USCIS fully withdrew the rule. So it kind of played out across the whole year. But this was a big deal, right? Because it proposed to change the H-1B lottery from a lottery to a preference system based on wage. Um, and this had a lot of people freaking out. It was really going to change the landscape of H-1Bs. But again, it was struck down so it was put out in January, struck down, and then finally withdrawn. So the good thing is H-1B lottery rule for the time being gone. How about February?
So in February, USCIS reverted to the 2008 version of the naturalization and civics test and also expanded premium processing to the E3 category.
I have to admit that E3 one was a little bit of a wait, what? They didn't already have it? But no, before February, you couldn't file premium processing for an E3. So these are, these are both, I would say, positive updates. Um, how about March?
So, in March, the Department of Homeland Security did designate Venezuela for temporary protected status for another 18 months. Um, and USCIS also rescinded the H-1B, some of the H-1B policy memos.
Well, let's talk about that one a little bit. That one's kind of a big one too. So USCIS had several policy memos which they were using to, they were the basis of, I would say, the majority of H-1B denials. Two of those memos in particular dealt with the employee-employer relationship and were used to attack anyone who was outsourcing, right? Because we know that the denial rates amongst IT outsourcers were the highest. And a lot was based on these memos. Hey, we need to see your contract with the end client, and that the length of that contract, and that really needs to lay out. Like basically, they wanted some contract from the end client that proved that it was a specialty occupation and was and laid out for 3 years. And it was. I understand why they were paying more attention to IT outsourcers because there is a lot of abuse and fraud in that area, but it kind of seemed the specific way they were going about it was kind of stupid, right? Because you had these people that were getting like approvals that were good for a day because like, well, that contract with the end client's good, is only good for this period of time. And it's like, well, yeah, but it's a 1 year contract, it's renewable, or we have a master services agreement, and then this is the specific contract. In general, this was, I would say, a good thing. And we immediately saw just a complete plummet in denial rates. I mean, part of that was, this was even before the Biden administration. This was at the tail end of the Trump administration, whereas initially H-1B denials had spiked under Trump, and then the denial rate started to go back down, in large part because of these um, three memos. Right? It was first there was some litigation and there was a settlement, and then they officially rescinded all of them in March of 2021. So what else happened in March?
So the U.S. Federal District Court struck down the public charge final rule, and honestly, I don't know if I'm more excited that we got some more, leniency on the H-1Bs, or we finally got rid of the I-944.
So I mean, in general, the public charge rule is something has always existed, right? That you have to, for example, if you're sponsoring a family member, you have to provide an affidavit of support to prove that the person won't be a public charge. And they're looking at like, have you taken any like certain federal benefits? And that's always been on the books, right? But it was a fairly like low bar for the most part, and the Trump administration really wanted to like ratchet it up and use this as a grounds to deny people. And of course, from an employment price perspective, this was just idiotic because I have an employer who's sponsoring me and paying me a salary. Like, why are we being lopped in with this whole thing to even begin with? And it created a new form called an I-944 that was like 20 pages and was essentially like applying for a mortgage. It was like, oh, we need your credit score and we need to know all of your debts and all of your assets. And, you're applying for residency, and the actual residency application was like, I don't know, a half inch thick, and then the I-944 was like 2 reams of paper. This is ridiculous. Like, we could quadruple the size of this thing, and I'm having to include bank statements and like, oh, do I have a 401k and my stocks and my mortgage and my car loans? And it's like, how is this like necessary, irrelevant? Good thing is that we only had a brief period in which we had to deal with this ridiculous I-944 and gathering all of this documentation from clients. It was insane to like be gathering essentially the full financial history of clients and being like, well, you're a good little saver, and ooh, you're a bad little spender over there. Just information that wasn't relevant. Anyway, obviously, it's gone. We're back to the sort of old rules. I mean, and good thing is we no longer have to include all this stuff when we file for an application for actual residency, right? It goes back down to just the little uh application. All right, April.
So in April, USCIS announced that F1 students seeking OPT optional practical training can now apply for their I-765 online, which is a great thing. Reduces the amount of paper and processing times. Also, USCIS reinstated the policy guidance instructing officers to give deference to prior determinations when adjudicating extension requests involving the same, petitioner and beneficiary, unless the facts, unless the facts show that there was material error, material change, or some kind of new material facts.
So the first one is like, why aren't we filing everything online? I mean, I guess we'll take a win where we can get it. They can now, but we should be filing everything all online, including all I-765s, not just OPT, but whatever. That's for right now. That's what we have. And, we're going to run with it. The whole policy deference thing, it existed pre-Trump, but they didn't really follow it. Of course, Trump got rid of it and now it's back. I mean, my hope is that they actually do start to really pay attention to that, right? Because on their end, it saves them so much time if someone's filing a straight extension to just be like, well, no, we're not going to waste time on this case. We have limited amount of time, limited amount of resources that we're always complaining about. And one way to save time and resources is to just not re-adjudicate every single case, right? If so, we've kind of started to see that. I think. I mean, I know like a lot of our H extensions these days. I mean, they've for the most part just been hopping right through. So we're kind of hope this trend continues. Um, so how about May?
So on May 10th, the Department of Homeland Security withdrew the 2018 notice of proposed rulemaking that proposed to remove the International Entrepreneur Program from the Department of Homeland Security regulation. Also, on May 17th, USCIS temporarily suspended biometrics for the filing of Form I-539. So this is for dependents of H's, L's, and E's.
Yeah, so the first one is they sought to get rid of something, and that was stopped. So the International Entrepreneur Program still exists. Um, Entrepreneur Parole Program, right? So this is not the EB-5, this is not the E-2 visa, this is something separate from all that. It's a parole that still exists. And yeah, I mean, the whole biometrics thing is kind of ridiculous because what it did is it took I-539 adjudications that were taking, well, a lot of times that were being adjudicated alongside the principal applicant and whatever their timeline was, whether it was premium processing 15 days or 4 to 6 months. And then all of a sudden they were being separated and now taking 14 plus months to file a straight extension of a dependent. Even though the principal may have been approved in 15 days, they were taking 14 months to approve the family, which was ridiculous. So obviously, suspending the biometrics has helped start bringing those processing times back down, because it was like, why do they need this? If they're not doing biometrics for the principal, why are we doing biometrics for the dependents? This is stupid. Especially when they have to do biometrics when they get a visa and then biometrics when they go through CBP. So what are we doing here? How about July?
Uh, really biggest thing for July was that USCIS conducted the second random lottery for the H-1B cap.
And it was not the first time, because they obviously the first time was the previous year, right? And then this was the second time they'd done a second round. But of course, it all bleeds into the issue that the new registration system is rife with fraud, and if they don't fix it, this is going to be a mess going forward. Anyway, we're going to kind of skip to October.
So in October, the Department of Justice and the Department of Labor both announced settlement agreements with Facebook that included a civil penalty of 4.75 million and 9.75 million for the victims.
Let's stop on that one for a second. We did a whole video on it, so if you are interested, go and look. The basis of the lawsuit was regarding Facebook's perm practices. If you really boil it down, they didn't like the fact that when their normal hiring practices were A and their perm hiring practices were B, right? And so they're like, well, you can't do that. We're going to come after you because that's discrimination. The problem is that Facebook was following the letter of the law. I actually strongly disagree with the settlement in saying that you may not like what Facebook was doing, but legally they weren't doing anything wrong. And most immigration scholars and stuff agree. Facebook actually did nothing wrong, but I think they just wanted this to go away. The key to this settlement was this was mostly driven by the Department of Justice, under, again, not under the DOL rules, but under anti-discrimination rules. The big question here was going to be, well, was the DOL going to sort of carry this forward and enforce it in perm applications? To date, I have not seen that happen. This just seems like the DOJ was like, we wanted to just make a point and go after the big boy in the room and then walk away. And it seems to be that is what has happened, that this is not carried forward. And now the DOL is going after people, like getting perm audits and stuff. Again, that could change. Haven't seen it yet. So we're hoping that the impact of this thing is limited to just Facebook. Because if it expands beyond Facebook, this could be problematic for a lot of people who, again, have done their perm recruitment legally, like in a legal manner, following the rules, but it hasn't necessarily lined up 100% with how they do their like sort of normal recruitment.
Right.
And
So
we have a whole
also,
video on it.
also in October, USCIS reached a settlement regarding H-1Bs for market research analysts, which outlined new guidance and allowed members of that class to file motions to reopen their cases.
Yeah, so this is kind of the point to take away from this going forward. I mean, if you're a member of the class, meaning you were denied during the time period in question, we did a video on this. You can maybe file a motion to reopen. The thing going forward is knowing that if you are a market research analyst, we should get less pushback from USCIS going forward. Again, everyone's case is a little bit different based on what your specific education is, but it just means um, less pushback for the specific category. The good thing is that there's a lot of arguments there that can maybe be applied to other categories. Again, unfortunately, we'll probably have to sue USCIS to actually get them to make those changes. But it's a good start. Um, all right, November, big, maybe one of the biggest lawsuits of the year.
Absolutely. So USCIS settled a federal lawsuit and agreed to two major changes. One, it declared it now considers E and L spouses employment authorization incidental to status, and it also added E's, L's, and H spouses to the list of categories that are eligible for an automatic extension of an expired EAD, employment authorization document.
Okay, so previously, if I'm a dependent, certain dependents were allowed to request work authorization. You file Form I-765 and you get your little card. One of the problems being is that those adjudications had gone from 60 to 90 days to 12 to 14 months. And it was people were losing their jobs because of this for no good reason, right? Other than just Trump administration shenanigans. Um, people were losing their jobs. And also, I've seen a lot of analysis to say this has actually played a kind of big role in why it's been so hard for employers to find workers. I mean, because you took it right here, you took upwards of 700 to maybe 800,000 people out of the labor market who wanted to work, were working, wanted to work, and you just took them out of the labor market. But anyway, so two things. What do they mean by H's and L's will be authorized incident to status?
So it's actually E's and L's are incidental to status, and essentially that means that you just need the notation showing that you are a spouse of an L1A or an E2, E1, and then based on having the approved I-94 showing that you are a spouse of someone in these categories, you automatically receive employment authorization without needing the actual EAD card.
Yeah, it means you don't have to file the I-765. You don't have to. It's just once you enter the US, you're automatically work authorized. Now, the problem is they haven't implemented that yet. So for the right now, E and L spouses still have to file an I-765. But here in the near future, talking about our look forward to 2022, this is one of those things where they're finally going to make that change in the system so that when you enter the United States and you get your I-94, it doesn't just say E2 or E1 or L2. It will say L2 spouse, right? And when it says L2 spouse, then you'll be able to use that I-94 to just work. No I-765 needed. But again, they actually haven't implemented that yet. And then the second one is certain categories have always been eligible for an automatic extension. So my EAD is expiring, I file a renewal, and while I'm waiting for the renewal, I'm automatically extended for another 180 days. And it did not include most of the work dependent categories like E's, L's, and H's. So now they have added those to the 180-day automatic extension, which on its surface sounds great, right? Because now if it's taking them a year to adjudicate my case, but I file on time, I may be the 180 days may cover the gap, right? Andrew, why is the way they actually wrote it out stupid and led to another lawsuit?
Because the way they wrote it is that you still need a valid I-94, which means that if you are, say, an H4 dependent and you go to file both the extension for your H4 and your new EAD at the same time, and they take forever to process, and your I-94 is still set to the old H4 expiration period, then even though you've timely filed, you don't get the extra 180 days because you don't have a valid I-94 until the H4 case is approved.
So it's 180 days or up until your status expires, whichever comes first. So again, if your EAD expires the same day as your I-94, and so you're filing an extension of your status and your work authorization together, you get no 180-day extension. And so I think they amended the original complaint and they filed the new complaint. So they're being resued over this. I think you're noticing a pattern here that in terms of Congress, doesn't do anything. They just bicker with each other and they haven't made any significant changes to our immigration laws in 30 years. And we know the agencies seem to only do bad things. So the only way there's any positive change over the last couple of years when it comes to immigration is lawsuit, 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 right? And we're just seeing like all these class action lawsuits. I mean, it's just you go to like any of the attorney threads where we're talking about like on Facebook and stuff, and you're talking about cases, it's always sue them in federal court, sue them in federal court. I mean, that's what we have to do now. It's our new world, and that's where most of these things are coming from. Oh, and then what was our other news from November?
So, for the first time, USCIS conducted a third random lottery for the CAP registration.
Why a third lottery? Because they selected a bunch of people, but barely any of them applied. Why would so few people apply for such a highly coveted visa? duplicate registrations. So, yeah, we're going to maybe talk about that a little bit farther down here. But yeah, third random lottery, first time ever. And we're going to talk about another first time ever here in December.
So on December 20th of last year, the Department of Homeland Security supplemented the H-2Bs for the first half of the fiscal year for the first time.
So when we say first half, right? People think, what? When is that? Well, the fiscal year starts in October. So there's the October H1 H2Bs, and then there's the April H2Bs. They supplement the April ones all the time, almost every year, because there's so much demand, because that's the summer, and that's when landscaping construction when the most demand is. Um, this is the first time I've ever supplemented the October window, because there's just always been less demand in that window. Again, the whole H2B program, in my mind, needs to be overhauled. When we're talking about, hey, we can't find enough workers, here's a great program that could be awesome, but the way it's administered and the rules makes it just completely worthless for most people and unwieldy. But anyway, so that's kind of our year in review for 2021. Mostly a lot of lawsuits that have made forced USCIS to make changes or stop them from making changes. So now we're going to look kind of at, hey, 2022, what do we have coming at us? We're going to talk about some proposed rules in a second, but first we're going to talk about just some of the kind of more generalized things or things that we need Congress to do. Andrew, what's the kind of first thing that we need in 2022?
EB5 regional centers to be reauthorized so that people can start getting back into that process.
So the direct investment EB5, right, has existed since the 90s, and it's a permanent program. Hey, I invest in 500,000 to $1 million in a business that I'm directly involved in. I create 10 direct jobs, right? The regional center program was created after the fact and was always renewed. Before it was renewed every 5 years, and then it got tied in with the budget. And every time they did a new budget, it got renewed, and then it got decoupled from the budget, and then everyone forgot it. Well, at least Congress forgot about it. So it just ended, and now it's been sitting off to the side, and we're waiting for it to be reauthorized. But in this case, this is something that has to be done by Congress. So I say, good luck to you. Um, I don't even know if this is going to happen in 2022. I mean, I sure hope so, because this facilitates billions of dollars of investment into the United States. Um, but we don't necessarily know if it's going to get reauthorized. And then if it gets reauthorized, what's it going to look like? Is it a straight reauthorization, or are they going to take the opportunity to pass significant amendments? Because we've seen a number of proposed EB5 bills. Some of them, a lot of the changes have been to like cement some of the agency memos, like make them actually officially rules by Congress. But a lot of them actually have been aimed at regulating the regional centers themselves, because that's where all the fraud has been, where the regional center rips off the investors. So we have to see if, as part of the reauthorization, it's a straight reauthorization, or if they take the opportunity to make changes. One of the things we forgot to mention is that they passed a rule raising the minimum investments from 500 to a million to 900,000 to 1.8, but then a court vacated that. So now we're back to the 500,000, 1 million. And everyone seems to believe that if they do reauthorize this, it will increase, they will increase the amounts. That definitely will be in there. And if, of course, if it's done by Congress, you're not gonna be able to challenge it. That's just going to be our new world. So you see a lot of people out there that are like, hey, if you want to do an EB5 investment, now's the time to do it, because we're back down to the 500,000 level. But again, we have to kind of wait and see. Andrew, what's the second one we're keeping our eye on?
I mean, hopefully we finally see the expansion to premium processing, which was actually passed in Congress over a year ago. At this point, has been going through the rulemaking process, and just we have not
Okay.
seen that get finalized yet.
We'll talk about that a little bit more in detail in a second when we go over the rules. So what's the next thing we're kind of keeping our eye on?
Potential H-1B lottery lawsuits.
Yeah, so there's a pending class action lawsuit right now. It's basically challenging the whole registration system as invalid for a couple of reasons, right? One, just they have a legal challenge that's straight up not allowed by law, and then they have a sort of equitable challenge, being like, hey, this thing's just rife with fraud. And when you guys were making the rule and you had the notice and comment period, that exact fraud was pointed out to you very clearly multiple times, and you just ignored it. Because when you do the rulemaking, they like when people point out stuff, they come back in the notice and comment, and they're like, yes, we notice your comment. We choose to ignore it, which is basically what they said. They're like, oh, but we don't think this is going to be a problem. And of course, they were wildly wrong. But we have to see, right? Because if this lawsuit, if they win and it's vacated, the registration system is vacated, then we're gonna revert to the old system where everyone had to file their full H-1B application, LCA forms, filing fees on April 1st, right? Let's just say a couple, in the old days, employment-based immigration attorneys, you don't talk to them in the month of March, right? There is no spring break. They're not available because you're preparing hundreds and hundreds of cap cases that have to be filed on April 1st. That was the old system. And if this rule is vacated, that's what they're going to revert back to, which again is going to be a nightmare because now USCIS is going to, like, the mailroom is going to have to receive 200,000 full applications in one day. I mean, it's going to be a nightmare. But the upside is it will cut out all the fraud, right? Because people are going to submit duplicate registrations when it costs $10, right? When I have to fill out all the forms, get an LCA, and include like $4,000 in filing fees, you're not going to see as much fraud. So we're keeping our eye on that lawsuit to see what's going. If you're thinking, well, is anything going to happen between now and this year's registration period? I highly doubt it. I think this year is going to go forward as is. And we'll kind of jump into some of these proposed regulations. So a couple of the ones we kind of have on the books. USCIS. What's our
Uh, yeah, so USCIS is talking about modernizing the H-1B requirements and oversight and providing some more flexibility to the H-1B program.
Now, we haven't gotten our hands on the text of this rule yet, right? So it's in the Federal Register, it's out there, but we haven't seen the text yet. But the 6 main areas it's going to cover: revises regulations related to the employer-employee relationship. So the first thing it might do is bring back. Remember we talked about those 3 memos that were rescinded. Well, they may be coming back. Part because they were memos. They did. The challenge was, hey, you didn't go through the proper process in order to start implementing these changes. You just did it in a memo. Well, now they're doing it through the rulemaking process. So if they bring back those things, but do the rulemaking process, it's going to be harder to try to challenge them and get rid of them. So they may be bringing those back. So if you work for like an IT outsourcer, keep your eye on this. This may uh, impact you. They're going to implement new guidelines for site visits. Figure that's just going to be like probably doing more. Provide flexibility on start dates in limited circumstances. Address cap gap issues. Strengthen the registration process to reduce the possibility of misuse and fraud. I desperately want to see the text of that one. It means they're not proposing changing the current lottery system. They're just proposing changing the registration system to somehow strengthen it from fraud and abuse. And I'm just like, I don't know how you're going to do that unless you just say a person can only be registered once. But then you're going to have a lot of companies being angry because they're like, well, what if I had a legitimate job offer and I didn't know that he had a second legitimate offer from a separate company? Like, because there are people that have legitimately multiple registrations that are 100% legitimate. So I will, when we see the text of this thing, we will do a video. And then the last one is clarifying the requirement that an amended or new petition be filed if there are material changes. There are going to be some discussion of when an amendment is required. Right now, what we have is a case called Matter of Simio, which is the one that kind of is the current standard for when an amendment it's required for an H-1B, but it looks like they may be providing some additional detail. Anyway, interesting rule, but we don't have the text yet. But when we do, believe me, we'll do a video on it because it's going to be, looks like it's going to be pretty impactful. What's our next USCIS rule?
U.S. Citizenship and Immigration Services working on their fee schedule, adjusting but really increasing all their fees.
So the one thing we have to remember is that USCIS is a fee-funded agency. So it's not like, a lot of other agencies where Congress just says, "Here's your budget. Here's the money you need." No, they're funded by the fees they receive. And apparently the amount of money they receive is not enough. And so the Trump administration tried to do this back in 2020, October, I think, 2020. They kind of jumped the shark. They didn't go through the full rulemaking process and it got shot down. But man, it was pretty dramatic increase, including like dramatic increases on things like asylum and some of these like refugees, which you're like, what? I understand increasing EB5s. These are $1 million investors, right? But like there was some increases in there that just seemed, I don't know, kind of like just being a jerk. Um, Again, we'll have to kind of wait and see what this looks like in terms of the fee increases. And then, of course, the third rule is the one we already, USCIS rule is the one we've already alluded to, right? Where Congress said you can increase the premium processing fee, you can double it to $2,500, which USCIS was more than happy to do day one. But then they're also supposed to expand premium processing to other categories, which of course they've just sat on their hands and haven't done for over a year now. I'm kind of like, what did they do with all that extra money? Like, if they're going to say, well, we didn't have enough money because we need more people to do additional forms, it's like, well, you've built up a year of double fees. So where'd that money go? Anyway, there is a rule that is in the works that would expand premium processing to I-765, so the employment authorization, and I-539, the cases for dependents, which I think is kind of dumb because if I pay premium processing for the I-129 and I file the I-539 with it, before Trump, they used to just do them together. They automatically would adjudicate the I-539 as a courtesy with the I-129. I hope this doesn't mean I have to pay $2,500 for the I-129 and then $2,500 for the I-539 when they're filed together. Um, Seems kind of low, but look, if that's what it takes to get it done, I guess we have no choice. To me, this seems like it should only apply to standalone I-539s, not ones included with I-129s. But hey, maybe that will be part of the rule. We'll have to see what the text says.
I would also want to see if I file an I-539, say for an H4 with my application for the EAD, do I have to do premium processing for both or is it just one?
You have to pay $5,000 if I don't want to lose my job, which that seems ridiculous. What I would really hope that they would do, to be honest with you, and they've done this for R's, right? R's, the premium processing fee for an R is 1,500. It's not 2,500, right? So you can, and I've seen proposals like this, like maybe they should do some carve outs. I don't know, to say, hey, an I-539's like the I-129, that's the employer, it's 2,500, right? But the I-539, maybe it's 1,500, right? I mean, to me, that
Yeah.
seems kind of like the right thing to do, but I don't know. They want their money. Now, Andrew, there's this DOL rule we need to talk about, but it's kind of a nuanced discussion, which we'll get into. What was the DOL rule?
So basically they're trying to strengthen wage protections for temporary and permanent employment of certain foreign nationals in the United States, and essentially try to change the prevailing wage methodology to increase those wages.
So, the reason this is nuanced is because the Trump administration put this rule out, right? Again, they jumped the shark. They skipped a lot of the process. And when we saw the actual wage rates, we're like, whoa. I mean, a lot of them were going up by like 50, 60% overnight, which was insane, right? To be like, no, 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 there's no way you can just overnight say I have to pay this person 50% more when I had no time to um we had no time to even prepare for this as a business, right? I can't suddenly, have my employment costs go up 30% overnight. So it got vacated. The Trump admin tried to republish it. Um, the Biden administration delayed it, and then it got vacated again. So as we currently stand, this rule is technically dead, but I can tell you that in general, they want to bring it back, and they probably are going to bring it back, but not in this exact form, right? So right now, what they're doing is they're taking in comments about the methodology for it. So what we're saying is that while this specific rule is dead, they are going to make changes to how they calculate prevailing wage rates, and they are going to go up. I mean, every year they do mostly go up every June, right? The FLC data center updates, and there are increases, like inflation and stuff. But I'm saying in terms of just a change to their overall methodology, um, is I'm pretty sure is going to happen eventually. Again, because the rulemaking process and where they're at, it probably wouldn't really even go into effect until 2023 at this point. But it's coming down the it's coming it's coming. Um, how about the Department of State?
Well, in keeping with our theme, the Department of State has proposed a rule to adjust their fee schedule as well. So this would include things like the current $160 fee for B's, J's, F's, and N's would go to $245. The $190 fee would go to $310 for non-immigrant visas, and from 205 to 485 for E's, and finally going from 125 to 510 for J waivers.
So again, hey, they need their money. The interesting thing is how the Department of State has been like, oh, we don't have any money, and it's like, well, you don't have any money because y'all closed down and you weren't adjudicating anything. So of course you don't have any money. It's not like because if you're a partially fee funded organization, it wasn't. I mean, it's your own making, right? you closed your doors for a long time and weren't receiving any fees. Um, but anyway, they're saying that it needs to go up anyway. So we'll have to see when this goes through. The interesting thing about the E1 is the E1 actually went up at one point to like over $400, and then they brought it back down to 205. It's the first time I ever saw a fee get lowered by the government. It was like, wait, what? Like, how much higher can you go? I mean, that's per family member too, right? So these fees are being paid per person, so they're not cheap. So if I want to, if I have an H and I want to go renew visas for me and my family, according to this, I got to pay 310 per person. Um, that's getting pretty steep unless your employer's paying for it. Um, so as of right now, the things we're keeping our eyes on are some proposed rules and some lawsuits. The other thing is we could keep our eye on Congress, but uh, I'm not putting a whole lot of faith that anything's going to come through Congress. One of the things to keep your eyes on, I guess, would be the Build Back Better bill because that did have some immigration provisions in it. Now, they had a plan A and then a plan B and then a plan C because the Senate parliamentarian kept saying, you can't do this, you can't do this, you can't do this. Um, Obviously, they were more focused on illegal immigration, stuff like that, but there were some provisions that did impact legal immigration in terms of like count, quotas and counting people, which would dramatically impact Indian and Chinese nationals applying for residency that are in these huge backlogs, especially Indian nationals. um, so there's some stuff there to also keep our eyes on. um, well, let's see here. I do see that we actually had someone ask a question, not necessarily related to this, but hey, why not? Let's answer it. Thank you for such a valuable information through. Let's see. I have a tourist visa. Okay. If I apply for the EB2 national interest waiver, can I enter the US while my EB2 is being processed? Huh. Well, to apply for the EB2 national interest waiver, you file a Form I-140. On the I-140, there's a box to check where you intend to apply for residency once it's approved. And you can check the box for consular processing, meaning once the I-140 is approved, USCIS kicks it over to the National Visa Center, who then sets you up to actually apply for your green card through the embassy or consulate abroad. Technically, if you sort of choose that process, there's no conflict entering as a tourist, right? The conflict is that if they see a residency process and I'm entering as a tourist, they're going to assume, oh, this guy's going to enter and then file for residency, which you're not allowed to do if you enter as a tourist. You're not supposed to do if you enter as a tourist. So it's really about the interaction between you and the CBP officer when you're entering the country, right? So if the CBP officer is like, well, hey, I see this case in the system, and you say, well, no, look, I actually have a copy of it right here, right? I filed my Form I-140. I checked the box for consular notification. I do not intend to apply for residency or adjust status is the word in the United States, but I'm going to do it. I'm going to come here temporarily, and I'm going to go back, and I'm going to finish that process when the time comes through the embassy. Technically, if you do it that way, there's no problem, right? So there's this whole, in general, tourists aren't supposed to apply for residency, and if they think you are, they'll deny the visa application or deny your CBP will deny you entry. And of course, what are the things they look at? Do you have a pending residency case? Are you married to a U.S. citizen? Things that would lead them to believe that you're going to apply for residency or try to stay. So can you? Yeah. But is there some risk? Yes. But then you can mitigate that risk by being prepared, right? So if the I-140 is in the system, have a copy of it, be prepared to argue, no, I'm consular processing my residency. So I'm really only here as a tourist and I'm going back. Andrew, any thoughts?
No, I think you pretty much covered it. I mean, you just want to plan ahead, basically.
Yeah. So again, it's really all about if you already have a tourist visa stamped in your passport, then it's really just about that interaction between you and CBP. And they may not even notice it. They may just be like, well, whatever, and wave you right through. If you're applying for the visa, that's a little bit trickier, right? Because you have to fill out a DS-160. There's a lot of questions there, and like it'll come out on the DS-160, and then of course, um, it'll come up in the interview. And the interviews are really quick, and a lot of times, they want to just deny you, not even like letting you talk about it. So if that's the case, if you're actually in a visa interview, be proactive about it and bring it up. Don't just let them sort of railroad you without even asking, because they might. Um, so let me see here. Oh, we got another question. All right, let's keep going here. Can a doctor recipient without legal entry get a green card through employment sponsorship? No. Um, because when you apply for residency, right, they're looking at three kind of basic things for your eligibility. Do you have a lawful entry? Have you maintained lawful status? Have you worked without authorization? So we do have clients that, for example, entered legally, let's say like on a tourist visa, and then applied for asylum, or maybe they applied for DACA and they got it before they turned 18 plus 6 months, right? Meaning they didn't accrue. We say that do you have valid status? They didn't accrue any unlawful presence, right? Because they got their DACA before they turned 18. Um, or again, they filed for asylum or something like that. And of course, with DACA, you get work authorization. In those cases, we do the green card component from the employer because that's not impacted by your status. We can always do that. We do like a perm, file your I-140. None of that. Your status is not relevant to any of that. We get the I-140 approved. They say, well, then next step is you apply for residency. Can I? Well, for the people that entered legally and then like filed for asylum or got DACA on time, um, they can continue in the residency process. They just have to complete it outside the US. So when they fill out the I-140, they check the box for consular notification. So once the I-140 gets approved, again, gets kicked over to the National Visa Center. They set you up for an interview. You go out, and you should be able to attend your interview and come back in without any issues, right? Because you're not inadmissible. Because again, you either filed for asylum or you got your DACA and you never accrued any unlawful presence or worked without authorization. But if you don't have a legal entry, then your only hope is to apply for a waiver. And a waiver for a green card requires that a qualifying relative, suffer extreme hardship. Qualifying relative in most cases would be a parent who is a U.S. citizen or resident, or a spouse who is a U.S. citizen or resident. So if you have a spouse who's a U.S. citizen or resident, we're doing this through the spouse. We're not doing this through your employer. Um, so again, if you had entered lawfully and then just you entered as a tourist, like with your family as a kid, and then just never left and gotten DACA on time, there is the potential to actually do the green card process through your employer. But if you entered illegally or without permission, there's really no way to do it through your employer. I mean, again, if you got a qualifying relative, but if you had a qualifying relative, why would we do it through the employer in the first place? We just do it through um, that. I mean, there are some exceptions, but those are other categories, like someone who's maybe eligible for 245I, or someone who's eligible for VAWA or U visas, because they kind of have their own waivers. VAWA is violence against women. It's just if you're married to a U.S. citizen or resident, and they, abusive. U visas are victims of crimes in the United States. 245I is people who were the recipient of an application before April 2001. Like, oh, hey, my brother filed for me way back in the day, and we just totally forgot about it. And you can pay a fine and get certain things waived automatically. So, unfortunately, in general, I'm going to say no because of the entry. Um, Andrew, any comments?
No, I think you kind of hit the nail on the head. It is kind of a very niche group that actually could, but generally there's some level of unlawful presence because
Yeah.
they didn't file for the DACA before 18 or something along those lines.
Well, and remember, you begin accumulating unlawful presence when you turn 18, and once you hit 180 days, you're subject to a bar. So the key is, did you get your DACA before you turned 18 plus 6 months? Because if you got it when you were like 20 and you were here the whole time, then it's like you can't even do the green card process, even if you have the lawful entry, right? Because you're subject to a 3 or 10 year bar, which would require a waiver, and the waiver for a green card process requires a qualifying relative. Now, there are waivers for non-immigrant processes, which are different. Those usually are just a balancing test. They literally just look at, well, what did you do versus why do you want to come, and it's just a balancing test. Those are for non-immigrant visas. So, like, oh, I wanted to get an H or a TN or something. The waiver you would need to get H or the TN is a much lower bar than the waiver you need to get the residency. The main difference being, though, to get the waiver for a non-immigrant visa, you have to go out, apply for the visa, and then wait for them to approve the waiver, which can take 6 or more months. So you'd have to leave the country and sit outside for at least 6 months, not knowing whether or not they're going to approve the waiver. So, in our experience, most of the clients who decide to actually go apply for a non-immigrant visa waiver were people who are already outside of the U.S., like they were deported. They're like, hey, I'm already out here. Why not? For people who are in the U.S., they're like, no, that's too much risk. Like, it's not worth it without any sort of guarantees before I leave. Which the only way to get a guarantee before you leave is if you apply for a waiver, a residency waiver based on marriage to a U.S. citizen, because then they can actually get the waiver approved before they go out. So then it's safer, right? Your risk is lower because, hey, I'm leaving it within hand rather than waiting it outside. Um, so yeah. Again, well, if there's more, oh, okay. What if the person that has DACA uses advanced parole? Uh, yes, if you're married to a U.S. citizen. That's kind of the simple answer. Why? Because again, I say, what do they look at? Do I have a lawful entry? Have I maintained lawful status? Have I worked on authorization? 3 things, right? If you're married to a U.S. citizen, then the only one they look at, or your parent is a U.S. citizen. I mean, your kid can be a U.S. citizen, but they have to turn 21. But anyway, if your spouse is a U.S. citizen, then they only look at whether or not you have lawful entry. That's it. Whether or not you've potentially overstayed or worked authorization is no longer relevant if you have a lawful entry and you're married to a U.S. citizen. But if you sort of fix your entry problem via advanced parole, we'd still have to look at, do you have overstay or unauthorized employment, which can't be just pushed away through a green card application via your employer. If you're married to a U.S. citizen, yes. We see that a lot, right? Where people entered illegally, get DACA, get advanced parole, which again, Trump administration got rid of it. Biden administration brought it back. Bars pretty high, but if you get the advanced parole, go out and come back, that fixes your entry problem, and you can apply for residency if you're married to a U.S. citizen. Via employment, it would only work if you got your DACA on time and did not accrue any unlawful presence beyond 18 to 6 months, or work without authorization. It's complicated. It's based on the specific facts of the case we have to look at, but I mean, it sounds like it's at least worth looking at. So, and look, in summary, 2021 was a weird year. Nothing positive happened via Congress or the agencies themselves. It's pretty much all via lawsuits. And the good thing is, hey, man, there's so many immigration attorneys out there that are like hip to this, and they're banding together to file these class action lawsuits, right? Not just, hey, I want to make money as an attorney. No, I mean, these attorneys from all over the country are banding together to push these class action lawsuits together. And we're just seeing more and more of them. So we hope to see positive changes in 2022. Just because A, the Biden administration, B, all these lawsuits going forward. As always, if you have any questions, come to us, go to our website. You can schedule a consultation with us to discuss whether it be your employment options or your family options, right? Because we're a full service immigration law firm with attorneys that do litigation, deportation, family. We can discuss all of your options and see what you may have. Also, as always, go and download our app, Law Pilot Guardian. It's available on Android, iOS, tons of useful tips and information. The basic app is free. So go ahead, download it, give it a look. Let us know what you think. And then we're continually, adding more features, integrating it with our case management software and all kinds of fun stuff. Andrew, any final comments on 2022?
Just hoping for more positive news.
And I think for the most part, we should probably see in general the positive versus negative news. I hope the positive news outweighs the negative in 2022. We need a net positive year, right? 2020 and
Absolutely.
2021 were wild, good and bad. We need a net positive year going forward. Anyway, hey, we're going to continue doing our updates. We're going to continue also with our series on the different immigration visas and green card categories. So again, if you're interested in a specific visa or specific green card category, go look at our videos. We have almost all of them done, so you'll be able to find useful information. But until then, thank you for watching. Let us know if you have any questions, and good day.